Start. Good morning. Court area. Affidavit filed. All right, we'll accept the affidavit. We will stop the proceedings which we had intended to initiate. Now, what arrangement is being made for
the consent? So, my lord, we are
dumping is now allowed. Mr. Gaurav Gupta, the Chief Commissioner BBMP, is present. The personal affidavit. Mr. Gaurav Gupta, Chief Commissioner, has been filed. He has tendered unconditional apology for the unintended disobedience of the court's order dated 6/3/2020. It is submitted that he has highest regards for the court orders and there was no intention in any manner to disobey the court's order. It is also submitted that now, in view of the consent granted by Karnataka State Pollution Control Board, the dumping of what waste it is?
Solid waste malad in Gitaganahalli malad quarry.
Solid waste can be done at the site. He will first off, he will ensure that the court's order is strictly complied in true letter and spirit. First off, Mr. Gaurav Gupta also ensures that he would be careful in future and will not involve himself in any manner in future which may constitute disobedience or non-compliance of court order. The affidavit, personal affidavit of Mr. Gaurav Gupta is accepted. We do not wish to proceed any further against him. However, he shall be more careful in future. Now, what is to be done?
On submission, there is an order passed by this board on 6th September 2019. Under when the solid waste management rules was framed of 2016, which came into force in April 2016. In that, direction is given under section rule 16, your lordship, duties of the State Pollution Control Board or Pollution Control Committee. So till date, no complaint is made, even though rule 22 has been complied now by the BBMP. And also state government has filed their affidavit on October 2019. So state pollution board has not done it till date. 6th September 2019. Because that solves the entire issue. The time frame is given.
What is not being complied under those rules?
They are complied with, that's all, man. If once that is complied, the whole problem of city will be, as far as garbage is concerned, it will be solved. It will be timely, time frame, it must be monitored. So what you look into rule 22, solid waste management rules.
In addition to that, may I make one submission? Not because this is not an adversarial litigation. This Honorable Court has been monitoring overseeing the enforcement of the rules. On 17
solid waste management.
19 order sheet.
Solid waste management rule 2016. Rule 16. Rule 16, 16.
These of State Pollution Control Board or Pollution Control Committee.
Yes, your lord. So 6th September 2018, there was a direction given as per Rule 16 and also Rule 22 by the BBMP state. Rule 22, your lord. Time frame is Rule 22. Kindly see for a moment. How it should be set up landfill. Rule 22. Right, is a suitable solid waste processing facilities.
We'll call for their response. We'll call for their response with respect to.
No, for that the state government has filed affidavit as per Rule 22 is concerned. As per Rule 16, it will be the overall monitoring should be monitored by the Pollution Control Board. So that complaint is not done even till date.
You could comply with the order of this Honorable Court dated 6th July 2021, where this Honorable Court has directed both my lord, Municipal Authority and the Pollution Control Board to come out with a roadmap for enforcement of the solid waste management rules. Main person, my lord, is the Pollution Control Board.
6/7/21.
Page number.
Page. 6/7/21.
6/7. First day should have been 6th September 2019. Then it is followed by, of course, the matter was not listed.
Direction number 4. Direction number 12.
Afterwards, another order was passed on 29 July 2021. Instead of coordinating, they have formed a company. That is also separate matter. The writ petition is filed. 29 July 2021.
You can say it is
There
already
are a series of orders passed.
there.
Let the petitioners
They file
file a detailed.
already compliance.
Then what they did after the 6 July order, 29 July, kindly see the order passed by this court on 29 July of 2021. Next one. Instead of forming the coordination under 2016 rules, 29 July. But today, the petitions were registered for examining the question whether the obligation of the Mahapalika and or the state government under the solid waste rules can be allowed to be performed by a company incorporated on the basis of the government ordered 5th March. And there is a separate petition has been filed, Your Lordship. So that even that has to be also examined. Instead of complying with 2016 rules, they incorporate a company on 5th March. For number 11338. My learned friend has filed that petition challenging the 5th March.
That's a separate petition, my
Separate
lord, on
petition.
the constitutionality of the company. But today, my lord, all I would submit, my lord, is that there are two stakeholders. One is the citizen and one is the BBMP. And what is being overseen is by the Pollution Control Board. I should say, my lord, because based on the directions of the Honorable Court, we have also interacted with the BBMP and they are doing a great effort in terms of whatever they are doing. The issue, my lord, is two parts. So long as the citizens don't do their duty of segregating the waste, because the waste has to be segregated into three streams. One is which can be composted, one is which is recyclable, and one which cannot be. So that if it is enforced, similar to how the COVID masks were enforced by the marshals, and there is an earlier direction by this Honorable Court, and by fining citizens, that's the only way, my lord. Otherwise, they will not comply with the aspect, because if they don't get the segregated waste, it's doubling the task of the BBMP. The other person who's a silent spectator is the Pollution Control Board. They are not doing anything. They have so many powers under them to enforce the waste management rules.
It's difficult to get the public to comply.
Please, my lord.
Very difficult to get the people comply with the.
My lord, if a direction is given by this Honorable Court with reference to seat belt,
no
Public
such
listen.
direction should
Given
be
that-
given, which knowing fully well that it will not be complied.
Schedule was amended, imposing fine under the old KMC Act. There is a schedule which is amended by the state government. Fine amount has also been increased wherever they don't segregate. But another aspect is that even if they segregate and give it separately also, while taking out to either any landfill or any other place, again they will mix it up. Now to some extent, some areas what they are doing, Thursdays and Mondays, they collect separately only the dry waste. And wet waste will be on other days. That is happening in several wards. See, that is implemented total entire Bangalore. This problem will be solved because separately they are taking the dry waste in a separate vehicle which comes to the each ward.
You
So
want
if that is implemented, it is the duty of the pollution.
same way they should do it in other areas also.
As my learned friend said, Rule 16, if the Pollution Control Board applied, definitely it can. Instead of that, they said they formed a company. That is the problem. When this court is, I am again monitoring this issue. And at the time when they are to submit their
Long-term action plan, so series of orders, what are
Earlier,
that
it
has
is
to be- they
better.
have to file
It is
the
better
status.
that you file a compilation.
Please, yes,
File a compilation, make a chart of it.
please.
What all directions have been issued, what have been complied, what is left is still to be complied, and what should be the action plan. It should be a joint action plan. You suggest what can be done to improve the thing. You suggest, then we'll consider it, then only it is better, then only
Yes, sir.
pass some order.
Yes, Lord, we'll do this.
That direction is
Before
already,
any order is passed, we must understand what all
Again,
directions have been issued earlier, what all has been complied.
Yes.
What is still to be complied and what more can be done.
Yes, sir.
I can see this 19/4/21. This honorable court has given already a direction what fell from the honorable court just now. 19/4. And we have met the people from the BBMP. And we have been working with them to try and see how best these orders can be monitored. 19/4/21. The other two stakeholders is what is the issue, madam. BBMP is doing a certain effort that should be complemented by the citizen and the pollution control board. 19/4/21.
Yes. But counsel for the petitioner as well as you appear for
Petitioner.
petitioner and you.
As per the seal number 1.2.
connected?
That was the first petition which I filed in 2012 when it is dumped in the Freedom Park. Garbage.
Mr. Uday Hoda, senior advocate appearing for Chief Commissioner BBMP.
ಇಲ್ದವ್ರೆ ಜಾಯಿನ್ ಮಾಡಕ್ ಬಿಡ್ತಾರ ಏನ್ ಸರ್ ಹೇಳುದು
Several orders have been passed by this court, issuing various directions from time to time. The compliance affidavit have also been filed by the respondents. It would be appropriate that the petitioner may prepare a chart giving the compilation of the orders of this court and the directions issued therein, as well as the compliances made by the respondents. He may also indicate the directions which have not been complied so far. The petitioner may also indicate the further action plan which is required to be taken.
Right.
In the meantime, the respondents shall continue to comply the earlier orders of the court and file the compliance affidavit on the next day. Give a date after 3 weeks. The officer present today need not appear unless called again.
13-4.
Yes.
Appearing on behalf of the respondent, madam.
Hmm?
I'm appearing on behalf of the respondent in serial number 2.
The respondents.
What is the matter?
34.
Yes, Mr. Wala.
I appear for the appellant.
Yes.
This, the company was not a major, not a party to arbitration agreement. Despite that, my lord, the arbitrator, my lord, has passed an award against the company. Therefore, we have to follow our logic. Your lordships are aware, my lord. Only parties to the arbitration agreement, my lord, are found by. This is the issue, my lord, for my lord consider.
You appear in the proceedings in 34.
Yes, my lord.
Whether you took.
They simply not go into it. Therefore, we have to follow our logic. We have filed the appeal. And my lord, the learned, my lord, the commercial court, my lord, simply my lord, confirms this order. Therefore, we have to go on. Without considering these judgments of the Honorable Supreme Court, where my lord, it has been specifically held that if you are not a party to the arbitration agreement, then my lord, you can't be party for the arbitrator, nor can there be a.
You have to hear it.
How the trial court has considered.
But can I persuade your lords to look at the trial court order, my lord, starts at running page, my lord, 15, my lord, 15.
Para 15.
Yes, my lord. Page 15.
Yes. Yes.
The trial court, my lord, says that there is section 11 order passed. Therefore, I am bound by it. I can't go into it. The section 11, my lord, they that's part. See, the Honorable Supreme.
But there were some judgments which said that if this aspect had gone into, had been considered at the time of,
Correct, my lord, absolutely.
then the arbitrator can't go into it. Where is the section 11 order?
But the section 11 order, my lord, get that. At my lord, the last page, at my lord, running page, my lord, 146. But the Honorable Supreme Court has held, my lord, the moment, my lord, the petition is filed, all that the court has, whether there's an arbitration exists, then in that event, we have to send it. All contentions, including my lord, jurisdiction has to be raised.
That's right. That's what,
Page 146, my lord, it starts.
that's right.
Page 151, last paragraph. That's all. There's nothing, no consideration of our being parties, not parties. Because of the Supreme Court judgment. Before the last paragraph, last sentence, unnumbered paragraph. Partnership deed contains arbitration. Rightly so. So only partners can be before the arbitral tribunal. The issue as to whether or not the company It is very,
Partnership contains the arbitration clause at clause 15.
yes, my lord. That is as far as the partners are concerned. Company is not a partner. And my lord, in the, before the learned
The
secretary, my lord,
dispute was between the company and
yes, my lord. They have now, my lord, proceeded against the company and say that, my lord, company should be made liable to pay the amount. They claim. And appellant is an individual. He is also, my lord, not a party to the arbitration.
after this finding that the arbitrator into this question.
That's what, so once there is a finding, there were some judgments which said that once a section 11 comes to the conclusion that there is an arbitration agreement, in a section 11 order, that there is a valid and binding arbitration agreement, then the arbitrator cannot get into it. There is one line of judgments.
Not all that the Supreme Court, my lord, in 2007. All that, my lord, the court has, my lord, 2019, volume 8, SCC 714. My lord, I'm sorry, I did not bring that judgment. My lord.
Are there some judgments which say that even a finding on the validity of an arbitration agreement under section 11 will not take away the jurisdiction to decide on that issue? There are judgments. You'll hear it. The opposite side. Respondents are ready. If they're ready, then we'll take it up.
Very well. Subject to, my lord.
My lord, my colleague is on her legs in another court. If the matter is can be passed over, she'll be before this honorable court to make the necessary submissions.
Then matter requires consideration.
Correct. Matter requires consideration. That's why I think the 2020
admit it.
We'll admit it and post it for hearing. Right.
Great.
Heard learned senior counsel for the appellant and learned counsel for the respondent. Full stop. Matter requires consideration.
Submission.
Right.
The transport has committed gross.
Right.
And coming to some conclusion that there was
That's right. In addition to reiterating the various contentions urged in the appeal and referring to the material on record, learned senior counsel points out that the trial court committed a error in failing to consider and appreciate that the appellants were not parties to the arbitration agreement allegedly contained in the partnership deed dated 1/4/92 and 26/5/2003, and that in the absence of a valid and binding arbitration clause arbitration agreement between the appellant and the claimants and the respondents, no award, much less an arbitral award, which was assailed before the trial court, could have been passed against the appellants. It is also submitted that merely because the arbitral tribunal was constituted pursuant to an order dated 18/11/2010 passed in CMP 9 of 2010, the said constitution of an arbitral tribunal will not oust the jurisdiction of the arbitral tribunal to rule on its own jurisdiction, and the impugned arbitral award as well as the impugned judgment and order passed by the trial court deserve to be set aside on this ground also. Full stop. Said submission of learned senior counsel for the appellant is placed on record. Matter requires consideration. Appeal is admitted. Post for hearing.
I'm appearing for petitioner, my lord. Already, this petition is already disposed of, my lord. The honorable court have directed to file compliance affidavit, my lord. the 10th respondent has to file compliance affidavit, my lord.
Petition disposed of on the Milord's undertaking given by the 10th respondent, which is an association which has put up the construction of the statue of Dr. Baba Saheb Ambedkar. Milords, they have undertook that they will shift that statue to their place. Milords, now affidavit appears to be a file. Last date they have not appeared, Milords. Now affidavit is on record. Milords, it's served to me. It appears, Milords, they have filed the affidavit. 10th respondent, Milords, who is association president. Sangha.
They have not served the copy of the affidavit to us, my lord.
Has to appear. 10th respondent has to appear, and Milords, his appearance is required.
Where is the affidavit?
Last.
Affidavit, Milords, is served to me. It is dated
Finish it.
21-1.
Then we'll close it. We'll accept this and close it.
Milords, but they have to shift somewhere, Milords. It is their responsibility what the court has. They can't leave
What
that
has
way.
been said by them in the compliance affidavit?
They have not stated anything. Very vaguely, they have said, madam, that the Tahsildar is conducting survey of some land, Milords, and they have.
No, they say alternative land has been provided.
No, it is not provided, Milords. I have spoken to
That is what they
Tahsildar.
have said.
Yes. Something.
What you are saying is unless that is actually complied with as directed by this court,
Yes.
matters to,
Yes.
there is no compliance,
Compliance, yes.
actual compliance.
It's not apology, Milords, for in between change of council, Milords, and all those things they have stated in the affidavit.
Mr. Revana Siddhappa,
He is representative of council. Hanmantappa Harvi Gowda.
Mr. Hanmantappa Harvi Gowder, you can direct the party and the council to be present before the court for the next date of hearing. Full stop. Affidavit dated 1/2/2022 has been filed by one Sri Revana Siddhappa, SB, son of Sri Basappa, on behalf of respondent number 10, as directed by this court, a wide order dated 13/8/21. Full stop. However, when the matter was called out today, neither the said Revana Siddhappa nor the learned counsel representing respondent number 10- association were present before this court. Full stop. Accordingly, we direct the matter to be relisted on next week only. Next 24 to 24/3/2022. Respondent number, the aforesaid Revana Siddhappa, as well as learned counsel Sri Hanmantappa B. Harvi Gowder, who has entered appearance on behalf of respondent number 10, are directed to be present physically or through video conferencing, or through video conferencing before this court on the next date of hearing. Failing which, further orders/directions would be passed in the present petition.
Manoj, I undertake to file wakalatnama on behalf of the respondents, Manoj. Received the wakalatnama yesterday. I undertake to file wakalatnama on behalf of the.
He wants time to file. Shri so and so.
Pradeep Naik.
Keystone Partners.
Please, Manoj. Pradeep Naik.
It is submitted that Mr. Pradeep Naik, Keystone Partners, has entered appearance on behalf of
the respondent,
the sole respondent. Registry to print the name of the learned counsel and relist on
2 weeks time, my lord.
2 weeks. Statement of objections, if any, to be filed by next date of hearing.
My lord, I seek for 10 days time to file my objections on behalf of 6th respondent. I have entered appearance on the last date of hearing. Last week.
Project Director, Department of Urban Development Cell. Can you accept notice?
Yes.
Learned AGA accepts notice on behalf of respondent number 5 also. in addition to respondents 1 to 3. Full stop. Learned counsel for respondent number 6 seeks time to file objections. Relist on 4 weeks.
Objections are required.
4 weeks. Statement of objections, if any, to be filed by next date of hearing.
Please.
This is for the appellant. The identical matter appeals cannot be honorable court of appeals to dispose of the appeals cannot. Same issue permitted to produce the order of the appeal as per the honorable court.
Okay.
Compensation.
Covered also. Same matter.
Same notification, is it?
Same notification, same village, and survey numbers are different and land owners are.
What has been done?
Dismissed. It's been dismissed.
Yes, sir.
So we'll dismiss yours also.
Yes, sir. As per this also.
Counsel for the appellant informs that under the similar facts and circumstances and against the same notification,
It's same notification.
this court, by judgment in order dated 19th of July 2021, passed in a bunch of MFA, leading case being such and such, has dismissed the appeals, holding that they are all devoid of merit. The operative portion of the judgment and order dated such and such the operative portion of the judgment order such and such is reproduced below. In view of above, the present appeal stand dismissed on the same terms as ordered by this court, by order dated such and such, passed in a bunch of reputation. No order as to cost.
I appear for the appellant in this case. Because the challenge to an order, a judgment passed under section 34 from an arbitration proceedings. But in a contract between the parties.
Christopher, we are called out serial number 7.
Lord, 7, I appear, Lord, for the appellant. Lord, there are 2 appeals, Lord, between
for
the
the
same parties.
What has
First
happened?
appeal, Lord,
Yesterday also same problem.
first appeal, my Lord, is 2-6.
Why is it not clear?
Lord, there was a suit for. Am I audible, my Lord?
No, you are not very clear.
May I seek a password, my Lord? I will try to log in through another system or come physically.
Just a minute.
Eviction case.
Who appear for the other side?
I am appearing for the landlord. Respondent number.
Yes. Now matter is to be heard finally.
Yes, Lord.
In the
I have
meantime,
complied with the interim order.
in the meantime, my lord, I have made an application for permission to withdraw the withdrawal of the amount in deposit. I am the owner of the premises.
Have you filed the objection to this? His application for withdrawal of money?
He has not filed yet.
Mr. Counsel for Appellant.
Sriranga.
Yes, Lord.
There is one
Yes.
There is one application filed, IA2 of 22, by the
It is-
respondent one, seeking withdrawal of the amount deposited by you pursuant to this court's order.
Yes,
You
Lord.
filed-
It has been served on me yesterday, my lord. I will file my objections to that. My lord, it's a peculiar situation where, my lord, I have been, my lord, I have been alleged to be a subtenant, and suit
Right.
was filed against me, but because I did not have any possession, my lord, at any point in time.
Only one question will arise. What has happened is pursuant to the decree, my lord, I have executed and taken possession of these premises and the premises in the connected appeal. The only question is whether I am entitled to mean profits or not. The original tenant, my lord, respondent number 2, he has not filed an appeal challenging the order of the trial court. My lord, on the execution side, what happened is we are not able to serve it. Arrest notice was taken to
If you
him.
want to press IA2 of 22, we have to hear him.
Yes,
If
my lord, that can be.
you don't want to press, we'll hear the main appeal, whatever you want.
Here the main appeal itself and dispose it of any time because I am 91 years old and I have to get more than 1 crore of rupees from these.
He doesn't want to press the application for
You
withdrawal.
don't want to press IA2 of
Fix a
22.
date for hearing.
The lordship may keep it along with the main appeal.
Both things can.
What happens is, once I.
All right, let him file objections. We'll see on the next date.
The lordship may hear it and
At
keep the
request,
application off the pen.
on request made on behalf of the appellant to file objections to IA2 of 22. Relist 2 weeks on the date.
2 weeks time is granted by the
Objections.
objection.
Grateful. Connected matters.
Both matters will not same.
It will remain connected. That
Yes.
we are not passing any order.
Only one thing I would like to make a request. In one matter, in 260, my lord, there is an order permitting me to proceed against defendant number 1, the original tenant. That order can be modified. In the first 262, there is an absolute stay. But in connected matter, my lord, I made a request because I appeared in caveat and said that could be confined only to the appellant. Your lordship may make it clear that the stay order will be operative so far as appellants are concerned. So that I can proceed
You will
executing.
see on the next date.
Yes, great.
Also challenge to an order passed under section 34 arising out of an arbitration proceedings. But this before the arbitrator was with regard to a contract under which, my lords, I as a developer of a software had licensed the software to the respondent. Plus, the terms of the contract stipulate what consideration is. It says that consideration would be the revenue earned from the use of the software. Plus, the arbitrator frames an issue as to whether I am entitled to this revenue, 10% revenue. Proceeds to hold that I am entitled to this 10% revenue. However, my lords, while concluding, the arbitrator comes to the conclusion that the word revenue is not defined in the contract and therefore proceeds to define what revenue is and ultimately concludes that revenue would mean profit and therefore makes me entitled to only profit and not the actual revenue that is earned by the respondent. Plus, before the commercial court in an appeal under section 34, the commercial court gives no finding on this aspect, but only says it's sound that the arbitrator has come to this conclusion and therefore dismisses.
बहुत जगह हार चुके हैं.
You'll have to show patent illegality
My lords,
in the arbitral award.
We are in 37.
yes, my lords, I'm in 37. May I take your lordships to page number 118 of the paper book, my lords?
Right.
At both places, you have failed to get any order in your favor.
Lords, if your lordships would see at point number 4, consideration is defined.
Right.
Lords, now what is consideration is there in the column, the boxes, my lords, your lordship, column 2. It
Right.
says 10% of the annual revenue
Right.
signed, delivered, and accepted by SLK customers in the territory.
Right.
Now your lordships will kindly look at the issue framed by the Honorable Arbitrator. Lords would kindly come page number 85.
Right.
Lords, at 85, issue number 2.
Issue number 2. That's right.
Claimant proves that the respondent is liable to furnish complete details of the revenue generated by it during the term of the business alliance agreement.
And is
it's
entitled to 10%.
10% of the revenue generated in terms of the business.
All right. What is the finding?
Your lordships will kindly look at the findings. If your lordships will kindly come to page number 97. Lords, at page number 97, issue number 2 has been discussed, my lords. They start at paragraph number 29.
No, is the finding that you are not entitled to 10%?
My lords, yes, my lords. The finding is that I'm not entitled to revenue,
Yes,
but I'm entitled
is
to.
obliged to review the revenue earned by it every quarter of the year. And if 10% revenue is more than the maximum guarantee, then the respondent shall pay the revenue difference between words. It's not 10%.
For the paragraph number 31, the arbitrator holds that what amounts to the word revenue used in the agreement not being clarified. The dictionary meaning of the word revenue in terms from property or investment income. Paragraph number 31. Because it was neither party's contention that I'm not entitled to revenue. Even the respondents did not say that I'm not entitled to revenue, nor was any party's contention that there is ambiguity in what revenue is. Despite this, the arbitrator, and it was not a term of the reference, the arbitrator travels outside the scope of the contract and then decides on this issue, which the arbitrator was not called upon to do.
So he takes the learned arbitrator, takes the gross profit.
Yes, ma'am.
And then at para 35 calculates it.
Correct.
Pure arithmetic.
Manoj,
What is wrong with the arithmetic?
arithmetic insofar as profit and revenue.
Right.
Revenue would be the entire amount that they earn from the use of the software.
Your contention is 10% of the turnover or the revenue.
Absolutely.
And not 10% of the
That is discussed in
profit.
the contract. That is defined in the contract. It did not need a further.
10% of the revenue generation.
Revenue generation.
What he has done?
Only on the profit, because and this contention section 34 court, how is it dealt?
You'll also get that in paragraph now, page number 45. Paragraph number 60. Looking at what the learned arbitrator has taken the gross profit on the ground that the word revenue used in the agreement has not been clarified. The learned arbitrator in paragraph number 31 has noted the dictionary meaning of the word revenue from property or investment income. By considering the same, the learned arbitrator has considered the gross profit from gross profit and net profit as it shows.
Third, learned counsel for the appellant. Issue emergent notice to respondent returnable by right 8-4.
देना चाहिए अगली बात के लिए आसान हो जाता है if the की what has been argued why so it is easier for
the next
to understand on the next day next day
For the respondent in this matter.
apologize in the first instance that some of the documents are in the vernacular, not translated to the place of record. Some of it, because I guess.
One time.
Sorry, Bulat?
One time.
I think it would be better if I place it on record notes because it's in the
Thank you
vernacular.
for the appellant. One time to place a translated copy of the documents which are in vernacular language. On his request, he said, give it
2/6.
Plus, the interim orders that I have paid all rents up to date pursuant to the orders passed by pursuant to the orders passed by this court, 65 lakhs I have deposited. Up to date rent till date I have paid.
Lord,
Which is
issue is very simple. Lord, it's a small issue which requires to be considered by your lordships. I have sought for modification of this particular order, interim order, which has been granted by this court. Lord, this order was passed by this court, Lord, without hearing me. I sought for filing my objections, time to file my objections. Lord, in the meantime, ad hoc arrangement was made, and at his submission, my Lord, amount was directed to be deposited before the BBMP authorities. Lord, consequently, my Lord, they have deposited this amount, but statement made by the other side that the entire amount is paid. Lord, that is wrong. Factually, my Lord, 6 crores is the entire amount that is due to the exchequer. That is why, my Lord, I have sought for modification of this order. He claims to be a tenant, my Lord, under me, insofar as, my Lord, public utility building.
Whatever interim order is there,
please, my Lord,
that will continue till next date. Now, he has sought adjournment today.
Absolutely, my Lord, there is no problem as such. But, my Lord, monthly, my Lord, he is supposed to pay me, even according to him, 2,37,000. My Lord, that no, absolutely wrong. That is wrong. My Lord, according to me, according to his own statement, my Lord, he was supposed to pay me 1 crore 20 lakhs. Lord, apart from that, every month he is supposed to pay me 2,37,000.
Suit is dismissed.
Suit is dismissed.
What do you want us to do?
My Lord, now that, my Lord, there are arrears of rent.
Well, what do you do then?
Lord,
no counterclaim by you.
There is no counterclaim from my side because he is continuing to occupy the premises, my Lord.
You want to nick him out?
My Lord,
you can't do that, right? So,
no, that is fine, my Lord. But what happens is he's at least, my Lord, he has to show some equities also. He's supposed to deposit the monies into.
For specific performance is dismissed.
He's dismissed.
The first appeal, we'll have to hear it.
Definitely, my Lord.
Right. So the interim order is status quo only because you can't physically, without due process of law, throw him out.
Yes. Then in the meantime, my Lord, he should deposit the monies also, my Lord. Every month, my Lord, he is supposed to deposit the money.
Dispute with regard to both of you file a memo of calculation, we'll consider it.
No, that has already been filed before your lordships. It is available. I have filed my application, my Lord.
We'll consider when the main appeal is taken up for hearing, we'll consider, and whatever finding we give with regard to arrears of rent, we'll incorporate in the main judgment.
What date you have?
A request for a short accommodation, my Lord, at least.
Second June, the interim order granted shall continue till next date.
Right.
Request for a date.
2nd June. 2nd.
In June, my Lord. At least prior to vacation, my Lord, at least. Lord, there is some urgency in the matter. That's the reason, my Lord, I am seeking.
What is the urgency? It is to be heard finally. I think more can be done.
The apprehension was same what BBMP did with Symphony Theatre. They don't want canopy to happen. Partial exhibitors.
No, I definitely understand that, my Lord. But at least, my Lord, he is occupying, my Lord, half an acre of land, and he claims that he wants, he has to give only 21,000 rupees as rent. Right. Half an acre of land in MG Road. Lord, that is what he is saying. No, that is not permissible. That's how
we fixed a date. We fixed a date.
For respondents. Defendants appeal not. Defendants appeal not against the decree passed by the commercial court. But 2 points not exhibit not. P1 to P4 not does not resemble not exhibit P5 to P8. Not the seal of the defendants appearing on exhibit P1 to P4. Not does not resembles with the seal appearing on exhibit P5 to P8. Not therefore not exhibit P5 to P8.
50%.
6 may kindly be not.
4 weeks. 4 weeks. 4 weeks, 50%.
Detailed order to be written, sir, for admission.
Admission to main ground. For admission.
Right. Heard learned counsel for the appellant and learned counsel for the respondent and peruse the material on record. In addition to reiterating the various grounds urged in the appeal and referring to the material on record, including the impugned judgment and decree passed by the commercial court, learned counsel for the appellant, who was the defendant before the trial court, submits that. What is the submission?
But the seal appearing on exhibit P1 to P4
The-
does not resembles with the exhibit
The
P4.
documents exhibit P1 to P4, that is VIZ, account confirmation documents produced by the respondent plaintiff, are fabricated and concocted documents inasmuch as the seal appearing in the said documents are not genuine, and consequently the said documents could not have been made the basis by the commercial court to decree the suit in favor of the respondent plaintiff.
P9 also not
It is also submitted that the interest calculation sheet at exhibit P9 produced by the respondent plaintiff is also erroneous and contrary to the material on record, and the suit ought to have been dismissed on this ground also. The said submission of learned counsel for the appellant is placed on record. A matter requires consideration. Appeal is admitted on IA number 1 of 19 for stay. The impugned judgment and decree passed by the commercial court is hereby stayed pending disposal of the appeal, subject to the appellant depositing 50% of the decretal amount together with up-to-date interest as on today, within a period of 4 weeks before this court.
May I make a submission? The sum of rupees 1,548,636 is an admitted amount, my lord.
Move an application. We'll see.
Please, my lord. I'll file an application.
Move an application. Then we'll see.
The appellant is the respondent before the arbitral tribunal, and the challenge to the award was rejected by the court below me. But in the award, all the issues are decided in my favor, but the money claim is decided in favor of the claimant. The arbitral award starts at ink page 67. The issues are ink page 70, man. The first 4 issues, even though I have not challenged the counterclaim in any proceeding under section 34, only the claim allowed by the arbitral tribunal. Ink page 70, man, the 4 issues. First issue, my lord, please again. Issue number 1, my lord, please to see it's dealt with in para 20 at ink page 75.
Against the rejection of counterclaim, is there a section 34?
No, man.
Right.
I'm only on issue number 1 to 4, my lord, because I have not challenged the section 30 in section 34.
Where are the issues? Page number?
70, man. First issue is, my lord, whether the claimant has completed the job on time.
Right.
The finding is at para 20, which is at ink page 75.
Right.
The above quoted statements of the respondent and evidence of CW1 clearly establishes that the work was not completed within the contractual period. Then, my lord, issue number 2, whether the claimant is entitled for 8.04 crores. Please see, my lord, para 21 at page 76. At the outset, it needs to be stated that in the claim statement, how the claimant has arrived at the set figure of 8.04 crores is not stated. However, in exhibit C7, the claimant under heading statement of accounts has stated how he has arrived at the sum of 8.0, which is claimed. The same is extracted here under. And then please see, my lord, para 85.
No, the statement of account, page
Yes.
76.
Yes,
Is there material to us? You have been awarded 3 crores 19 lakhs.
I have suffered an award of
They support an award of 3 crores.
on 3 headings.
Sorry?
3 headings, my lord.
Right. Which are the 3 headings?
My lord, it's at para 27, 28, 29, page 78. At the bottom of para 27, in page 78, bottom of para 27, therefore the unilateral invoking of bank guarantee is against the contractual terms, besides being not justifiable. On this, my lord, they gave me a irrevocable bank guarantee. Because they did not complete the terms of the contract, I invoked the bank guarantee. The second aspect is in para 28. The claimant claims that he spent 15 lakhs towards renewal of bank guarantee charges. Clause 9 obliges the claimant to provide a bank guarantee and keep the project current till completion. The claim of the claimant that he spent 15 lakhs towards renewal is not disputed. Hence, claimant is justified. This is also not provided under the contract.
That's
Third
right.
aspect, Mal.
Bank guarantee is invoked. Guarantee did not provide, or the contract did not provide for issuing notice before invocation. In the question of saying that illegal invocation is wrong.
Same thing for the bank guarantee charges or for the aspect of paying insurance to their contractors' employees.
They have appeared already.
Yes. What is your contention?
Please, my lord.
Yes.
Now, with respect to the bank guarantee, it is at page number 78, my lord, please. Para 27. However, the only justification for invoking the bank guarantee made by the respondent as per the evidence of director of the respondent company, so Mr. Sanjay Uttam, in his affidavit filed as evidence is that the company has no option but to invoke the bank guarantee due to the unprofessional.
Madam, the argument is the contract does not provide that they have to intimate you. And there is no bar for unilateral invocation of bank guarantee. So unless you can show that before invoking the bank guarantee, they were liable to inform you and they cannot unilaterally invoke it either by under the contract or any other provision or some judgment, then this finding is not supported by anything. This finding at para 27 is not supported by any term of the contract, not supported by any statutory provision, not supported by any precedent. That is one head. He only pointed out one head. It's 2 crores.
With respect to the definition of clause 1.1a, defines the contract document to include the general condition of contract. Obliges contractor to provide a bank guarantee from a scheduled commercial bank of so and so.
Right. Heard learned counsel for the appellant and learned counsel for the respondent and peruse the material on record. Full stop. Registry to secure the TCR by the next date of hearing. Interim order of
Yes, ma'am. One submission on that. My lord, when after passing the award, they had filed an application under section 9.
Right.
This came to be allowed and it was challenged before this honorable court. And my lord, this is in page 121. Right. This honorable court, my lord, as per the operative part at in page 129, directed me to deposit 2 crores as security, which I have deposited already, my lord.
Already there.
It's already there.
Right.
I may be permitted to withdraw the said amount, my lord, because
I've also given a property for Mysore as security in compliance with the order of this honorable court at in page 121. Therefore, my lord,
you get the records. Security has been provided.
Yes, ma'am.
Security
page 129.
as directed by this court has already been provided.
Meantime, I may be permitted to withdraw the said amount, my lord, because along with interest is close to almost 6 crores 80 lakhs, my lord, please.
3 crores 10 lakhs is a award amount.
19 lakhs.
19 lakhs.
Yes.
You're disputing the entire 3 crore 19.
Yes, ma'am.
Only a portion.
The whole month, because
you pointed out bank guarantee 2 crores.
bank guarantee, retention money of 1 crore,
Right.
interest, insurance for the employees, which is their employees,
Right.
and the contract charge that comes to 3 crore 19 lakhs.
Right.
The total amount, my lord, is not from the contract. It is outside the contract. Therefore, I've given a security of the money and the.
Let the records come. On IA number 1 of 21 for stay, comma, it is pointed out by the learned counsel for the appellant that in Commercial Appeal 116 of 2021, dated 7/10/2021, 7/10/2021, filed by the respondent herein, this court, respondent hearing, arising out of proceedings initiated by the respondent under Section 9 of the Arbitration and Conciliation Act 1996, this court disposed of the appeal by directing the appellant herein to deposit a sum of rupees 2 crores within a period of 2 crores in addition to certain other directions. Now, in addition to issuing certain other directions, full stop. The operative portion of the order dated aforesaid order passed by this court reads as under. Extract page 129, 130 and 131. Full stop.
I'm sorry to interrupt. In that class too, they have already stated that.
And it is extracted, right? Full stop. These directions by way of an interim arrangement remained in force till disposal of the suit by the trial court, culminating in the impugned judgment and decree passed by the commercial court. Full stop. Under these circumstances, we, without expressing any opinion on the merits without prejudice to the rights and contentions of the parties, and without expressing any opinion on the merits / demerits of the rival contentions, we deem it just and appropriate to direct the aforesaid arrangement as per the directions issued by this court in Commercial Appeal number so and so to continue to remain in force pending disposal of the present appeal also. Full stop. Registry to secure the TCR relist of June 1st week.
The execution proceedings should not be precipitated.
Right. We deem it appropriate to stay the operation and implementation of the impugned judgment and decree passed by the trial court by continuing the arrangement.
Right.
Right.
For the respondents.
Challenge the Section 9 order of the trial court. In the meantime, the parties have mutually agreed on certain terms of settlement. The parties are not from Bangalore. They are present today in court and have signed the joint memo that we intend to file. If I may be permitted to pass it across the bench to the court, it's been signed by both the parties and the councils.
What has been done in Section 9? What order has been passed? Which is under challenge?
Section 9, in fact, granted a mandatory injunction whereby the appellants in this appeal were directed to supply power for a certain amount of time.
Next week,
Parties are present, so they have. We'll list it next week.
Parties are present today.
Where is your affidavit?
The dispute is settled, my lord. We have entered. The dispute is settled between the parties. We have entered into joint.
Give the compromise affidavit.
Give us the compromise petition.
Where parties are present, call them.
Both parties are present.
You identify them.
Yes,
Identification the registrar को भेजते हैं.
Right. Actually, we do it here. Let them go before the registrar will come back.
And along with the
or immediately now. Verify the affidavit and then come back.
take the joint memo of consent terms filed today. The court is taken on record. And counsel for the appellant submits that the appellant as well as respondent have entered into compromise and have settled their dispute amicably outside court.
Respondent number 1. Okay, not respondent number 2.
Respondent one. Respondent number 1. The compromise affidavit has been filed. The parties to the affidavit are present before the court. First off, let the joint memo of consent terms, which has been filed today before the court, be verified by the registrar judicial. The parties present before the court shall be present along with their counsel before the registrar judicial. The report of the registrar judicial regarding verification of the joint memo of consent term shall be filed before the court. Put up at 2:30. You just get this order first, sign it, and let it go. You take the order and then go before the registrar judicial for verification. Ask someone else. Orders here. You go and get the order.
Justice Krishna Kumar had asked us to hesitate.
Call somebody
Does
else.
not seem,
Let her go.
doesn't seem like it from our side. Great. This is an appeal under section 37 against divergent findings. The arbitral tribunal, my lords, was constituted pursuant to nominations made, my lords, by both parties, and a unanimous award at page 64 came to be issued, my lords, holding that the termination of my contract as the contractor, my lords, was illegal, and consequently granting me, my lords, damages to the tune of 5.02 crores. The lordships find at page 69 the 6 issues that have been framed by the arbitral tribunal. The first issue at para 7 is regarding the validity of the termination. Now the tribunal, my lords, goes at great length to find basis as many as 10 reasons as to why this termination, my lords, was grossly illegal. And your lordships get that at page 83. Middle of that paragraph, we have held, based on facts and circumstances, that the respondent has not fulfilled his obligation under the contract. These are stated below. There are as many as 10 substantive reasons, my lords, assigned, including the fact that there was no provision for termination and no notice was issued. In fact, not 10, there are 11, clause 11. 10 is there is no record to show that the claimant refused to perform the contract, but on the contrary, he has requested the respondent to issue the drawings and supply cement, etc. 11, there is no clause for the termination in the contract agreed to by the parties, nor is there any procedure agreed between the parties under the contract for termination. And accordingly, at para 28, my lords, the termination was declared to be just and illegal. Consequently, my lords, damages were awarded to me, which tabulation is made at page 105. The details, my lords, are in the table. Claim 1 is regarding the termination. Thereafter, my lords, claim 2 is regarding compensation for loss of profit, which we claimed at 3.70 crores. It is awarded, my lords, at a 15% formula for 2.25 crores. And accordingly, my lords, certified bills payments and escalation charges are awarded, tantamounting, my lords, at page 108 to 4 crore 53 lakh 14,000, with interest, my lords, of 49 lakh 60,000, coming, my lords, to 5.02 crores, and further interest of 18%. But this was a unanimous award, my lords, passed in 2008. Proceedings were pending before the trial court, my lords, for as many as 14 years. In the interregnum, the respondent, my lords, was foisted with a contempt proceeding because he breached an order under section 9. He thereafter, my lords, was subjected to an order by this honorable court, which your lordships get at page 210, which has also been disobeyed. And there is a contempt petition now pending against him, my lords, in CCC number 176 of 2022. Page 214, my lords, is the operative portion. In view of the declaration made by the learned counsel appearing on behalf of their respective clients, it is directed as under. Respondent shall furnish the bank guarantee of rupees 5 crores to the city civil court, declaring that in the event the award is confirmed, it would be open to the court to encash the bank guarantee without any objection by the respondent, and such bank guarantee shall be furnished within 1 month from today with the court below.
The respondent.
Not
Nandakumar, section 34 order.
no reasoning.
What is the section 34 order?
Sorry, my lord.
What is the section 34 order? Is it?
34 order sets aside the award.
Sorry?
It sets aside the award.
So what? Where is the reasoning?
Please, I'll point. Not a whisper regarding termination, which was the moot issue.
Right.
Everything the petitioner has argued has been accepted as if the respondent has not even appeared. Can I point out a few more points? Let my esteemed friend complete them.
Right.
Since my lords are on the 34 order.
34 order.
Yes, my lords, just see. There's not a whisper regarding termination.
Let him point out. Yes. Yes, please point out what reasoning has been given.
There are a few submissions that I want to make. But as far as admission is concerned, I really can't stand in the way. That's entirely your lordship's prerogative with the appellant. But there are some other points that I want to bring to the court's notice.
So how the order is sustainable?
Please,
What
I'll tell you
reasoning
what.
has been given?
Please, the order
Why
is
setting
sustainable.
aside the award?
Fundamentally, the award, my lord, goes well beyond the scope of the agreement. There are parts of the award which say the arbitrators record that this is.
Where in section 34 proceedings the trial court has recorded that?
Please, I'll point out. Please come. Please come to
Page?
Page 45, ink page 45.
Yes.
Para 22.
Yes.
One of the grounds urged in AS 22 is that the finding of the arbitral tribunal regarding award of the claim and regarding escalation bill is erroneous. Claims 5 and 6 pertain to the payment of certified escalation bills. In the arbitral award at page 33, at para 44, it was held that this is a claim of the claimant towards escalation in cost of materials and labors. Admittedly, there is no provision under C2 and C3 for payment of escalation. Please, let me show you lordship the award. It starts with the language, yes, there is no clause for escalation. Therefore, it's outside the scope of arbitration. However, at page 35, para 47, it has been held that there is an implied agreement expressly performed by both the parties. Arbitral tribunal has held that the payment of escalation was a claim repeatedly made by the claimant and it is certified by the architect. It is a contention of the petitioner that he has refused and denied the claim towards escalation since he has never agreed to pay any price of escalation and that the contract dated so and so does not provide for the payment of escalation. The said finding is contrary to the terms of the contract since there is no provision under C2, C3 for payment of escalation. May I just show your lordship from the relevant portion of the award? The arbitrators start with the language and say there is no provision. Please let me point that out to the court. Please see.
So that is one head.
Yes, that is one head. Quite so. I'll read further.
Please come to.
Yes.
Come to 23.
Para 23. One of the grounds in AS 22 is that the arbitral tribunal failed to notice that the only issue to be decided was whether R1 was prevented in performing the contract and whether it was the petitioner who refused to perform his part. Please give me 1 minute. I'll place the.
Can we read further?
Please let me read this. That it is not. I'm sorry. Who refused to perform his part? That it was not disputed that R1 refused to perform, pleading non-supply, when in fact there was no such shortage. Therefore, the issue was whether factually there was a short supply or obstacle in performance as discussed in para 14 of the award. According to the advocate for the petitioner, there is incorrect calculation of cement bags by the arbitral tribunal at para 15 of the award. Arbitral tribunal has held that the claimant was prevented from continuing the work for want of supply of cement, that the work came to a stop due to non-supply of cement by the respondent at the present petitioner and not due to unilateral stoppage of work or abandonment by the claimant. Further, by considering exhibit so and so, so and so, and so and so, arbitral tribunal came to the conclusion that cement left to the respondent is only 2 bags. The learned advocate for the petitioner argued that there is an error in arriving at the said 2 bags. According to him, as per exhibit so and so, petitioner had supplied 300 bags of cement. On so and so, respondent 1 supplied 50 bags of cement to the engineer. When such is the case, the same is reduced to 250 bags. However, the closing stock of cement as on so and so is shown as 154 bags. This is from the award. On 1/7/2006, respondent 1 supplied 50 bags to the engineer. When such being the case, 104 bags were left over. Arbitral tribunal comes.
Contention.
No, I'm sorry, my lord. This is from the award. The learned judge is remarking from the award. That's what I wanted to point out. All this is recorded in the award. There is a manifest error. There is a manifest contradiction. I'll point this out to the court. It's not as if, my lord, he's saying it from the records. He's not reappreciating the evidence.
Let admit it. We'll admit it.
Please.
Your lordships may be inclined
To remand it. That's what
Send
we
it
thought.
back.
Send it back because
in a time-bound manner, so that firstly, let the learned AS court adjudicate the question of validity of termination. Only thereafter the rest follows. Escalation, etc., is an incidence of damages. Once it is found that the termination is manifestly unjust, damages have to follow, my lords. And those damages are the discretion of the arbitral tribunal.
But with utmost respect, that may not be entirely correct. I'll tell your lordships why. There are 3 reasons or 4 reasons that are given for the termination. The first is that there was an incident at the site.
Claim number 1.
Yes.
Is not even referred to.
I'm sorry, my lord, that may not be entirely correct. Please permit me to point out from the award. Please permit
Not
me.
the award. From the
Sorry?
section 34 order.
Yes. No. Please. What I'm saying is that the 34 order only goes by the award.
Right.
Award is manifestly self-contradictory. It
The
cannot be
award-
sustained.
Award in
Yes.
the tabular columns.
Yes.
Claim number 1 is with regard to termination.
Please, I'm grateful.
Where is the reference to that finding in the section 34 order?
Please permit me for 2 minutes, indulge me with seeing the award for a minute. I'll thereafter show your lordships the 34 order.
Right.
There is a cause and effect. That is why I'm trying to point. There is a cause and effect insofar as this termination.
All right, where is the award page?
Please turn to internal page 12 of the award. That's at ink page 75.
Right.
Yes.
Paragraph 14 at the bottom. Both respondent and claimant have admitted contract does not contain a termination clause, but respondent so I'll skip those last 5 lines of that paragraph. Dispute pertains to the period from 22/6/2006 to 1/9/2006, which is the date of the termination order by exhibit so and so. During this period, claimant states he was prevented by the deliberately from carrying out the work and is given the following causes. 1, non-supply of materials by the respondent which he had undertaken to supply. That's only cement. That is what is referred to by the.
Kumar,
Yes.
finding on claim number 1.
Yes.
Where is the finding on?
I'm just showing your lordships this from the award.
You want to know is there a finding on claim number 1?
Lord, the finding is on the cause of claim number 1.
Is there a finding on claim number 1?
Lord, I would submit yes, because it is on the finding.
If there is a finding on claim number 1,
yes.
Will the finding on claim number 1 impact the remaining claims or not?
Well, I respectfully submit that it might impact it.
If it impacts,
Having said, I'm sorry.
If it impacts, then why doesn't the section 34 court refer to the finding on claim number 1?
Yes, because what the court has done is to refer to the cause for the termination, not the termination itself.
At least,
yes.
Section 34 court should have said that we are referring to the cause for termination.
Yes.
Therefore, there is no need to say anything about the finding on claim number 1, and therefore I proceed.
I am not able to justify the language used by the learned judge.
It's not about,
should have said this or that.
Not about language, because the scope of section 34.
Quite so.
We can't substitute our reasons and say 34 order is correct because for some other reasons.
Please. I'm entirely with your lordship.
Unlike an appeal or.
Please come to paragraph 23 for an answer.
No, how much ever we deliberate, if there is no finding by the section 34 court on claim number 1 as recorded by the tribunal, even today or after 5 years, it has to go back.
Lord, please see this. Your lordships are quite right. But the point is this. Claim number 1 is a consequence of the termination.
That is your argument.
Yeah, no, that is his case also.
All right. That is his case. Why doesn't the section 34 court say that?
Lord, I am not able to say that because the tribunal says that. The award says that.
Therefore, we want to send it back to the section 34 court. If you are agreeable, otherwise we'll admit it.
But I leave it to your lordships.
No, leave it. You'll have to consent. You'll have to give consent.
With the consent, we
With
can
consent
remand the
only we
matter
can
to
send
be
it back.
decided.
Please, within 4 weeks or 6 weeks, as your
It is
lordship.
better for both the parties. It is better for both the parties.
Please.
Let both matter be remanded.
You may have to take instructions from the party. I don't know.
No, I would agree.
Please, Lord, can I just, in that case, make one? I don't know what the.
Otherwise, we will record our finding that there is no finding.
No, Lord, I have no difficulty for a remand order insofar as the 34 is concerned.
But there is one aspect I wanted to bring to the court's notice. Please permit me to do that, and thereafter. There is a petition that is filed by me challenging the award quite so. There is also equally a petition filed by him challenging those portions of the award that were not granted. Now, as we speak, both petitions were allowed. But the challenge is only insofar as one out of the two petitions. So the setting aside of the award stands insofar as his petition is concerned as we speak.
Rejection of his section 34 is not challenged.
No. It is allowed. His petition is allowed.
Allowed. Oh,
Please
that you are not
point
challenging.
that out to the court.
Sorry.
Please.
You are not allowed.
Yes.
You are not challenging it.
Yes, he's not challenged it. I am not challenged it. Please come to page 59.
Right.
Why I am pointing out is, really speaking, the remedy is that we have to go back into fresh arbitration. Neither of us are happy with this award. Please permit me to point out paragraph 29. In Com AS 27 of so-and-so, that is his petition. First respondent, who is the claimant before the tribunal, has challenged the award insofar as it relates to rejection of claims so-and-so, so-and-so, so-and-so. He's also challenged the award relating to allowing counterclaims so-and-so. Your lordships have it, my lord, I'm sorry. I'm so sorry. Ink page 59, internal page 27 of the order of the 34th.
I will not press my AS. I will not press my AS. The remand may be
so
confined.
commercial AS 27 filed by you.
Has been allowed.
In fact, both have been allowed.
Right.
But now, my lords, I have not.
It's a common order.
Yes, a common order. Mine is one counterclaim and some enhancement. And I am submitting on instructions.
If we have to remand it, we'll have to remand only commercial AS 22.
Very well.
Subject to the condition that you will withdraw commercial AS 27.
That's what I'm trying to submit.
And the 34 court will only decide.
That doesn't stand anymore because it's already been allowed. The award does not stand today. In law, the award does not stand. That's what I'm trying to submit to the court. There is really, this is a peculiar situation. Please permit me a minute to point this out. Please permit me to read, my lord, para 29 and 30. It will not take too long. Com AS, who is the claimant, my lord, it may now not be possible for him to withdraw it. That's what I'm trying to say. Insofar as it relates to rejection of claims so-and-so, he's also challenged the award relating to allowing of counterclaims so-and-so. According to the arguments of the learned advocate for R1, the said counterclaim is bad. Please.
If we set aside this order,
yes.
Then the common order on 22 and 27 will be set aside.
Please.
Both will revive. We'll direct the section 34 court to deal with only 22 and 27 filed by him will be withdrawn.
Please. That would be the right course. Please. That would be the right course.
Please.
That's right. Right. This appeal by the respondent, is it? Respondent number 1 dash defendant number 1 in commercial arbitration suit, that is Com AS number 22 of 2008, is directed against the impugned judgment and order dated 23/2/2022, passed by the LXXXII Additional City Civil Judge Bangalore (bracket Commercial Court), whereby the said petition/suit filed by the respondent, filed by the appellant under section 34 of the Arbitration and Conciliation Act 1996 was allowed by the commercial court, thereby setting aside the arbitral award dated 14/4/2008 passed by the arbitral tribunal comprising of the sole arbitrator. Heard learned senior counsel for the appellant and learned senior counsel for the respondent number 1 and peruse the material on record. Full stop. For the order proposed, notice to respondents 2 and 3 is are dispensed with. That's right. Dispensed with. Full stop. The present appeal arises out of a claim petition filed by the respondent number 1. Sorry, filed by the appellant herein against the respondent number 1. Full stop. The said proceedings having been contested by the respondent number 1, the arbitral tribunal, sole arbitrator, by three member arbitral tribunal, by the aforesaid arbitral award dated so and so, the arbitral tribunal partly allowed the claim of the appellant party allowed the claim of the appellant.
And one counterclaim of the rest.
As well as full stop. Having been contested anta ittala. So also further, the respondent number 1, in addition to opposing the claim of the appellant dash claimant, also put forth a counterclaim. Full stop. By the arbitral award dated so and so, the arbitral tribunal allowed the claim of the appellant in part, as well as the partly allowed the counterclaim of the respondent number 1. In relation to one counterclaim. Full stop. Agreed by the impugned, agreed by the arbitral award insofar as it related to rejecting the claims of the appellant dash claimant and allowing one counterclaim of the respondent number 1. Full stop. By the impugned common judgment and order passed in Commercial AS 22 of 2008 and Commercial AS 27 of 2008, the commercial court allowed both the suits / petition, thereby setting aside the award dated 14/4/2008 passed by the arbitral tribunal. Full stop. While the impugned judgment and award insofar as allowing Commercial AS 22 of 2008 filed by respondent number 1 has been assailed by the appellant in the present appeal, the allowing of Commercial AS 27 of 2008 by the commercial court is not the subject matter of the present appeal. Full stop. On instructions, learned senior counsel for the appellant submits that we'll say it later on. Full stop. After having heard the learned senior counsel for both sides, a perusal of the impugned judgment and order passed by the commercial court will clearly indicate that despite the arbitral award specifically dealing with and recording a finding as regards claim number 1,
Kindly not say that, then it should not be that.
All right. Will indicate that the commercial court has not considered and appreciated the material on record, keeping in mind the scope of Section 34 of the said Act of 1996.
No finding has been reported.
Full stop. It is also seen from the impugned judgment and award that no finding
has been awarded that claim number.
No, the argument is it is already there. On the claim number 1 regarding termination.
Termination, there's not even a
Your
word.
Lordship may refer to termination.
Right. It is also seen from the impugned judgment and order that though the arbitral award records a categorical finding, records a finding with regard to claim number 1 put forth before the tribunal, the commercial court has proceeded to pass the impugned judgment and order without either adverting to or referring to the said finding recorded by the arbitral tribunal. Full stop. Under these circumstances, it is also seen that the impugned judgment and order passed by the commercial court suffers from various other illegalities and infirmities without taking into consideration the scope and ambit of Section 34 of the said Act of 1996. Full stop. Under these circumstances, without expressing any opinion on the merits / demerits of the rival contentions before the trial court, as well as before the arbitral tribunal, we deem it just and appropriate to set aside the impugned judgment and order passed by the commercial court and remit the matter back to the commercial court for reconsideration afresh in accordance with law. Full stop. At this stage, learned senior counsel for the appellant submits. That's right. Submits. Adnan, we'll do that. Submits that the appellant would not upon setting aside of the impugned judgment and order passed by the commercial court and remitting the matter back to the commercial court for reconsideration afresh, the appellant who had also preferred commercial AS 27 of 2008 would not pursue the said suit/petition, and the claim of the appellant herein would be restricted to commercial AS, restricted and limited only to commercial AS 22 of 2008 filed by respondent number 1. Submission made on behalf of the appellant is placed on record, and accordingly we deem it just and proper to set aside the impugned judgment and order passed by the commercial court and remit the matter back to the commercial court for reconsideration afresh, for reconsideration of only commercial AS 22 of 2008 afresh in accordance with law. In the result, we pass the following order. Appeal is hereby allowed. Impugned judgment and order dated so and so is hereby set aside. The matter, the commercial AS, the matter is remitted back to the commercial court for reconsideration afresh of only commercial AS 22 of 2008 in accordance with law. Next, parties undertake to appear before the commercial court 2 weeks date. After 2 weeks, on 4th April 2022, without awaiting further notice from the commercial court. Next, on 4/4/2022, the appellant hereby undertakes to file a memo seeking withdrawal of commercial AS 27 of 2008. Full stop. The commercial court shall proceed to consider and dispose of commercial AS number 22 of 2008 in accordance with law within a period of
Intervening vacations.
4 months.
It will be 3 months. It's 2008. I don't think there is.
3 months ago.
3 months.
Arguments have to be advanced.
3 months from the date of from 3 months from 4/4/2000. Right. All rival contentions are kept open. No opinion is expressed on the merits/demerits of the rival contention.
Briefly applies. Great.
But he's done dismissed.
That's right.
Some IA.
Exemplary order. That recalling. Today also nobody is there.
But this is just application.
Right. IA1 of 22 and IA2 of 22 are filed. Please, right legs. IA2 of 22 is filed by the petitioner seeking recalling of the order dated 6/10/2017, dismissing the present petition without further reference to bench. Full stop. IA1 of 22 is filed by the petitioner for continuation of delay of 1176 days in filing IA number 2 of 22. Full stop. The learned counsel for the petitioner is not present and the matter is called out. Full stop. Accordingly, the applications are hereby rejected for
want of prosecution.
Want of prosecution.
At the outset, my apologies to the Honorable Court, my lord. Because our counterpart could not be present on the day when the matter was called.
Wanted to file objections.
I filed my
They have filed the objection, no rejoinder is to that because
I have filed my rejoinder, my lord.
not to my objection they have filed. The government has filed objections for which copies.
I am yet to receive a copy. No, I'm sorry.
On a counsel for petitioner applicant, as far as allowed, 2 weeks.
Alert.
2 weeks time to file rejoinder affidavit to the objections filed by the state. Respondent is paid.
16.
They joined the complaint.
I have filed. Subsequently, another affidavit was compliance was filed. Earlier, they said they have complied with the order of the Honorable Court. Subsequently, another affidavit was filed. Kindly see another affidavit filed by Balaram, claiming to be under secretary. First affidavit filed, he said he has complied with the order dated 24/2/2020.
Come to your prayer. What prayer you want to be granted? Relief.
Relief is only to
remove the re-employed person in all government department of Karnataka in accordance with circular
29th of February 2016.
provide
There was a
employment to
circular.
the unemployed.
There was a circular.
PIL. Have you impleted all those persons who have been re-employed?
I have not impleted.
Then they are the person who would be adversely affected in case any order is passed.
Must my kindly go to 28/5/2019 order.
Who are you? How can you? You are unemployed person.
No, I am not an unemployed person. I am a retired person, my lord. Now, the
Right.
question is, Lord, I am
You are not given the employment.
No, I am not also.
What is this
I am
type
aged
of
about
PIL?
75 years, my lord. I am aged about 75 years. I cannot even seek for re-employment. First of all.
These persons, they have been re-employed, must be for some period. Some period.
Now, you lost my on 29/2016. This honorable government has passed an order. There cannot be any re-employment of the retired employees.
What type of
No, these people are also retired. The persons who have been employed retired. So it is personal interest.
employed, they also retired.
They also retired. Petitioners also retired. They have been re-employed. Petitioners not re-employed.
Yes.
So PILs because they have been not re-employed.
That's on 25/2019 order.
Looks like a completely private claim because you have not been re-employed. They have been re-employed.
No,
He's not interested.
not my claim that I have to be re-employed.
Then what is the ground?
No, you lost my claim.
What is the locus?
29th of February 2016. There was a circular.
No, what is your grievance? You are also a retired employee.
Yes, I am a retired.
Persons who are re-employed are retired employees.
Fault is ours. We entertain such type of. Yes.
Kindly go through. On
We are going through what all has been done till now
now,
in
what
this such type of petitions.
court has said, unless the
We are also at fault for entertaining such petitions. This is what we want to know, why this petition has been entertained. How it can be entertained when you have not even implemented the persons who would be adversely affected.
1,000 employees are there now.
45.
1,000 employees.
Therefore, there is no need not to be implemented.
Now the question is for order.
And by one stroke of pen, they all should be removed. What is this type of petition?
On 29/2016, their defense was, your Lordship, page number 64, that they can employ the approving of the cabinet. That is also not the prospective. It is only a retrospective. 64 may circular may sign it. Annexure A circular is dated 29/2016, wherein the court, the circular says no, there cannot be.
We cannot entertain such type of petitions in absence of the persons who would be adversely affected by our order.
The affidavit clearly indicates, my lord, they have employed
several persons.
Maybe.
Earlier, there was nothing was there. I can't give
And so far as that circular is concerned, it is for the state government to decide. This public interest litigation has been filed. Karnataka, what is Karnataka land grabbing prohibition act? What it has to do with this?
They're employed there. There is a special court for land grabbing.
Right.
So the contention is that there are no rules to employ them there.
Now the court is to see whether the courts can function smoothly or not in this without any pleading.
They filed an appeal. They have not complied with the direction dated 24/2/20.
24/2/20.
20. They also firstly go to order dated 28/5/2019.
Yes. What is your stand
with regard to implementation of the circular?
Yes, Lord. That's what.
Because the court has already asked, that is why we are asking you. That circular is still in force. That circular is still in force. What is your stand?
Implemented in all the departments.
Affidavit dated?
Affidavit dated 21/2/2022.
No, it says 2/2/22.
Then there is one more. Filed on 22nd October.
See, we have one affidavit dated 25/11/21.
Yes,
then we have one affidavit dated 2/2/22. We don't have it here.
Give us your stand. What is there in the affidavit instead of.
I read this affidavit. I submit that the details in particular pertaining to the appointment of retired government servants in various departments of the state government was furnished by the department to the Department of Personnel and Administrative Reform to our department as per UO note dated 7/2/2022, along with the statement a copy of the same is published here with the annexed argument. I submit that I'm going through the particulars furnished in that by the Department of Personnel and Administrative Reform state that the circular dated 29/2/2016 is substantially not implemented in all the departments of the state. I submit that the two retired employees are reappointed for Karnataka land grabbing prohibition and special court, and cabinet approval is taken for reappointment of these 32 retired government servants. I submit that the Department of Personnel and Administrative Reform, one retired government servant is reappointed for the post of Under Secretary, Governor Secretary.
No, the circular says don't re-employ.
Yes.
Your stand is that circular which says don't re-employ has been substantially implemented.
Not implemented.
Substantially not implemented. Sorry.
This ground goes, no?
Right.
This ground goes. That is the only ground.
That's the only ground. That's right.
And whatever employment has been done, that has been done after taking prior approval of the cabinet.
Correct.
In 32 persons in the land grabbing court.
That's right.
And some more persons in some other department.
Right.
They are not before the court.
That affidavit is there. Affidavit copy.
That is, these persons are not before the court. We cannot find any order adversely affected.
Annexure may kindly be seen.
No, we'll record this latest affidavit and close it. What more can we do?
Not implemented. Not, let's say it is implemented. Substantially not implemented.
Substantially not implemented.
Philosophical and
That
29.
is a stand. And that's what you wanted also.
My content is have to be removed because on 29 2016.
We cannot issue any direction for removal of all those persons
Let us take action in
without
accordance with law.
hearing those persons. They are the adversely affected persons.
Rashmi, kindly see, the circular says.
Circular,
Prospective.
you have not come here for the implementation of that circular. You have taken it as a ground to challenge the re-employment. That is all. We will deal with it. But in this public interest litigation, the petitioners have prayed for following relief. At the very outset, it is to be noted that the re-employed persons are not party to the present proceedings. In case any order is passed by this court with regard to the re-employment of these persons, they would be adversely affected. So, the sole ground on which the petitioner has approached this court in this public interest litigation is that the circular dated 29th of February 2016 has been issued by the state government saying that no re-employment shall be done. Sarah, the learned AGA appearing for respondent submits that affidavit dated 22nd of February 2022 has been filed, stating therein that the circular dated has not been substantially implemented in all the departments of the state. It is further stated that in certain re-employment have been carried out. Certain retired employees are re-appointed for Karnataka land grabbing prohibition special court, which has been done after taking cabinet approval for reappointment of 32 retired government servants. It is also submitted that in the Department of Personnel and Administrative Reforms, one retired government servant is reappointed for the post of Under Secretary to Governor Secretariat. In the Department of Personnel and Administrative Reforms, in bracket DPAR, bracket close, vigilance, 13 retired government servants have been reappointed with cabinet approval. Full stop. The persons who have been re-employed are not before the court, and as such, we are of the considered view that no orders can be passed which may adversely affect these re-employed persons. Full stop. The writ petition has not been passed, has not been filed for implementation of the circular dated 29th of February 2016. It has only been prayed that all such pre-employed persons who have been re-engaged contrary to circular dated 29th of February 2016 shall be removed. We are of the considered view that in absence of the affected persons, no such relief can be granted. The repetition is accordingly dismissed.
Permission to the password matter. 230.
Yeah.
Password matter. 230.
अच्छा, that.
Two IAs, IA number 1 and IA number 2 of 20 are pending, my lord.
File objection if you want.
I have filed objection to the main petition itself, but it is fully covered by the judgment of this one.
No, he wants to make certain amendment. IA1.
That may be allowed, but no consequence.
My
Sir.
submission, my prayer for, in addition to the prayer sought in the main petition, I had sought for another prayer directing the fifth respondent environment officer to grant environment clearance certificate. Though all pleadings and necessary assertions have been made in the petition, original petition.
If he has no objection, we will allow your amendment application. Heard on IA number 1 of 2020. This is an application for amendment in the prayer column by the petitioner. Learned AG appearing for respondent has no objection. The IA 1 of 2020 is allowed. Petitioner counsel is permitted to carry out the proposed amendment in the prayer column of the petition within 3 days, 1 week, and file the amended petition, copy of the petition after giving notice to other side. The IA number 2 of 2020 is production of additional documents. It is allowed. Counsel for the petitioner is permitted to place on record the additional documents. Give it after 2 weeks.
Possibly after vacation,
It's covered.
He says that it is covered by some judgment.
On the last meeting, similar submission was made in video conferencing, and still dealing, a document was produced which is unconnected to this writ petition or the facts and circumstances of this case, and got an order for that.
Make it after vacation. After vacation.
Being
The government advocate, my lords,
No.
there cannot be such submission.
No. He cannot make such submission.
Why not?
I
Because I made.
I'll
I want-
convince this honorable court, Lord.
Let it go after vacation.
Number 18.
Sent to the direction dated 7/12, filed affidavit of the deputy commissioner. That's on 15th March.
Order was partially completed, but not yet to started.
Putra.
Sought for another 3 months time in the Para 10.
Let me make submission.
Yes, 9 years had passed. You have not.
Yes, for the reason that my lord say it is a land which was reserved. Some application for untried equations were filed. For that reason, it could not. Now, my lords, everything is clear. Now, layout is also, my lords, partly.
That was earlier also.
No, my lords, it was not there. My lords, 176 plus Hakkupatras are handed over, showing, my lords, each of the sites to them. I have stated, Deputy Commissioner has stated on oath. Now, my lords, Taluka Panchayat, which is, my lords, not made a party, which that is an agency, my lords, which is forming the layout.
Now, whether you have extended the benefit of the scheme to the beneficiaries or not.
Yes, my lords, it's extended. 90%, my lords, it is only, my lords, now. My lords, photographs are there, my lords. A list is made available to along with the affidavit.
Compliance Act. 14/3/22.
Yes.
Compliance Act.
100%.
Millers, layout Millers, laying road Millers, executive officer, Taluk Panchayat Millers, I am not Millers representing them. They are not a parties before the court. It is that agency Millers has to implement. Plus, we have deputy, as a deputy commissioner, we have seen that Millers amount is also released in their favor. I have stated in the affidavit. Recently, Millers 73 lakh, Millers, everything is done Millers. Only Millers it is laying roads and Millers.
Close.
By intervention only Millers it is done Millers. I am not saying that.
Partly complied. Fully complied.
तो कह रहे हैं बाकी उनके हाथ में नहीं. Whatever remains is not in his hand. That agency.
Amount is also released now in their favor.
Huh?
Executive officer Taluk Panchayat, who is authority Millers to form the layout. Millers, they are not the parties before this court, but still Millers deputy commissioner has undertook that Millers. He will monitor and Millers he see that Millers it should be completed. Laying of the roads, Millers, drains, etc.
They are all subordinate to respondent number 4.
No, they are not subordinate Millers. They are the local bodies.
Panchayat.
Panchayat is not the subordinate Millers. Let him not Millers. He has not made the party. I am not taking such stance Millers. This Millers differently able person Millers. I understand there is a delay. Millers authorities are Millers complying Millers. It's not that. Either Millers may close it, all Millers may adjourn by 2 months. Millers will. They will Millers will be Millers will be all happiness Millers they can leave the court. It is the intervention of the court, Millers. They at this stage it has come. It's not that there is a delay on our part also. I am not saying that.
No, the first step is Hakkupatra.
No, Millers. First step is identification of list of beneficiaries. That Millers, director of disabilities.
That has been completely
That
done.
is completed. Hakkupatra of 176 persons have also handed over, showing them a physical site.
First step, as you said, is identifying the persons.
Yes, that is done.
That is completely done.
Yes, including handing over the Hakkupatras to them.
176 Hakkupatras have been
Handed over to them, showing the Millers site, actual sites.
Right. So no,
Out of 202, you have
202
given it
Millers,
to
yes.
176 only.
Yes, because Millers others, their whereabouts are not known. If they made available Millers, Millers may record my undertaking that within 2 weeks Millers will hand over. They are not available. That is difficult.
11 members are not available.
Whoever is there, let them go to Tahsildar Millers. We have instructed, he is present here. Millers, immediately.
Other 15.
यही लिखा था.
Correct.
Other 15.
They may go and contact will get also.
And registration, their documents are ready.
Registration, formal registration of the Millers sale did would happen.
Not
That I have
3 months time.
3 months. So I have stated.
Identification of the beneficiaries, handing over of Hakkupatra, registration, all that is there. So far as further release are concerned, amenities, we can't do anything in the absence of the Panchayat.
My lord, registration is not done.
Millers, I have stated on oath that in 3 months we will do it.
But
On affidavit, yes.
if you want further directions with regard to the layout
It is not-
amenities, that they are not in a position to do.
maybe 2 months time may be granted after the vacation, which can be.
For registration, they have to come, my lords.
You'll have to implead the panchayat. If you want that layout to become a proper layout with all the beneficiaries having pakka sites with Hakkupatra registered and amenities, you'll have to implead the panchayat.
I will make necessary application. Yeah, granted for them to.
What can be done? So that one
very badly.
latest status report with
No, my lords, may I make one suggestion? If my lords permit, 73 lakh has been received, my lords, by the executive officer. He cannot keep quiet, my lords. My lords may record that and close with the direction to the executive officer.
Executive officer of who?
Please.
Executive officer of the panchayat.
Executive officer of Taluk Panchayat,
Correct.
which is implementing.
Let him come. That is your statement. Let him come before the court.
Or my lords can issue direction. It is not that, my lords, they will keep the money with them and my lords.
Compliance affidavit along with documents has been filed by the learned AGA dated 14/3/2022 and the same is received on record. Learned counsel for the petitioner seeks permission to implead. Yav panchayat, which panchayat?
Executive officer Taluk Panchayat, Anekal.
The Anekal Taluk Panchayat represented by its executive officer as additional respondent to the present petition. Full stop. The said request for permission to implead the aforesaid panchayat is hereby granted. Petitioner permitted to implead Anekal so and so as additional respondent number 32, 34. Also, petitioner to amend cost title and file amended cost title by within period of 3 days. Full stop. Upon needful being done, issue emergent notice to additional respondent number 34. The panchayat, ಅವ್ರನ್ನೇ ಬೇರೆ ಇರ್ತಾರೆ. Otherwise, he himself.
I would not have asked for impleading.
Right. Realist June on date.
Yes, ma'am. Meantime, I also will report everything.
9th June.
Great.
But in this case, my lord, I was supposed to file statement of objections. I seek indulgence of 2 weeks, my lord. It is already sent to the court.
I need AGA press for allowed 2 weeks further time to file a statement of objection.
Obliged.
Taken or 8 or 11 April is my lord.
Give one more date. Give date.
This badge relates to forest development tax, forest development fee.
Supreme Court.
Matter is pending, of course, in the Supreme Court, both with respect to the first challenge to the notification note and thereafter the amendment made to section 98A. And those matters and court note are coming up before Supreme Court on 24th. 24th likely to be.
First week of June? First week of June.
Let them not precipitate, because what's happening is, apart from this, there are several matters which are pending, and every time, my lords, the DCF, my lords, says, I am not a party, and he starts issuing notice. So if that is made clear,
already some interim orders granted.
No, in one of the matters. But I don't know.
We will record his statement that they will not precipitate.
I don't know how many are there like this, because there are
You are on the one hand, you are taking the plea that matter is pending before the Supreme Court.
Correct.
What's happening?
And
On
the other hand, if you will proceed, we will have to restrain you.
What has happened is, if that is forest development fee is struck down, but forest development tax continues on the statute book now.
Then we'll argue that, my lords, if my learned friend wants, pursuant to the
Are
constitution.
you precipitating? Then you argue it. We will not adjourn the matter because the Supreme Court is seized with the matter.
And these are pertaining to after the caution. These are all not, my lords, the demands here after the decisions.
Otherwise, you don't precipitate. Because both things cannot be said.
So the whole difficulty, those are all with respect to minerals. This is with respect to timber. And timber, which is being taken away from the forest, there is a tax imposed on them. Their argument now is GST has come, therefore this tax doesn't apply. So the point in the single judge's case, they argued that because of FDF being struck down, you can't impose
the tax. And that's how, my lord, the entire returns are before
No, the fee, the validity, rather your right to levy the fee is pending before Supreme Court.
That of course, the
Or whether it is fee or tax doesn't make a difference. Is it? After the GST regime came, whether you call it a fee or a tax doesn't make any difference, does it?
If it's a fee, it will make a difference, but the tax it will possibly be subsumed, my lord. That's the
That has to be resolved by the apex court, and which will probably be resolved with regard to tax and fee when they decide it. So till then, don't do anything is what they're saying. Otherwise, refund and all that.
Is there any interim order in other matters?
In matters, there are interim orders. What happens, lords? The Forest Department conducts lots, auctions in various depots. So
Which case there is an interim order, we will extend it to all the cases. That is all.
some other DCF holds an auction, he says, I am not a party.
whole difficulty, my lord, if we succeed ultimately to recover
The
it.
last date pointed out.
That's right. No, all these writ appeal is against which order?
Writ appeal is against a consent order, but I will not stand on technicalities. Lords, your lordship can decide that. I will not, because it was considered before the learned single. It's a consent order.
What do we do with writ appeal?
Lordship, we keep those also pending.
Those also
because,
pending.
our submission is that it was on a misconstruction of the order of this division bench that the submission was made. And that is how, my lord, we have filed it.
So, in none of the petitions, there is any interim order, is it?
There are some
in the
interim
writ petition, in the first writ petition, my lords, at serial number 20, there is an interim order on 9/6/2021.
We got time.
9/6/21.
In the writ petition, there is an interim order. On
There is an interim order. There is already a
His lordship, Justice Satish Sharma has passed an interim order.
right. Now, in the writ petition, in the very first matter,
Lordship, we take the second matter, my lord, the writ appeal filed by the state.
that's right.
Not done at that time. But in case now the matter is pending before the Supreme Court and we have to adjourn the matter on that ground, then we will extend the benefit of this order to other cases also. That is all. Thank you.
That's right. 9/12/91 order, is it?
Yes.
9/12.
9/6/20. Your lordships are referring to the writ petition, my lords, or the writ appeal. Writ petition.
9/6/91.
9/6/2021.
9/6/21.
There is an order saying no coercive steps till the next date of hearing.
No, it only says there shall be an interim order on 9/6/21.
6/8, Lordship, they see 2/8.
He order है.
One, the writ appeal.
9/6.
619.
The 9/6.
619.
Writ appeal, 619.
21.
2/8.
अरे भाई ये नहीं है.
The first matter.
2/8 and 110.
So your demand notices, you shall not take precipitative coercive steps pursuant to the demand notices. That should suffice till the matters get disposed.
Because all I'm really saying is, if ultimately we succeed,
Right.
then we should have a recourse to recover that money.
Right. So shall not take precipitative coercive steps pursuant to the demand notices issued to all the.
Problem arises, every time they hold an auction, one of the conditions imposed is when I bid the 12% FTF, and in some they mention it as FTF, and in some they mention it as FTT.
That's what this court has said. Even in the writ appeal, no coercive action.
That will
Right.
These are a bunch of
What learned senior counsel is saying is when they hold fresh auction also, they will impose the same thing. Again, we'll have to rush to court. So therefore, don't hold auction or hold auction without the condition.
Without that condition.
I don't.
They should not blacklist. They threaten to blacklist the bidders. Every time we have to issue a legal notice.
We will pass only
Not a
this
party.
order. If you want, we may only pass this order that no coercive action.
Yes.
That is all.
Right.
In all the matters.
Or your lordship may observe not
Mind
insist
order
on payment of FTF. That will, my lords,
No, that will affect every single auction.
naturally, it is a levy, my lords, which is part of the federation itself has got an order. My lords, ultimately, my lords, then again, my lords, they have.
Even in Dharwad, Gulbarga, we saw that individual petitions are being filed and interim orders are being granted. So what he's saying is,
Not to insist, they can put it on demand.
Which is what I was respectfully saying. Let the demand be there. Let them not insist on the payment at that point in time.
And but subject to the condition that ultimately, if we succeed in the Supreme Court, then they must be liable to make
that,
payment.
of course,
That
that's
condition
always
has to be there. No, no. But
Shall we say this? Shall we say realist so and so? Meanwhile, respondents shall not, I mean, the state shall not insist on payment of forest development tax/fee in relation to auctions already conducted, to be conducted till next date of hearing. Is that okay?
Yes,
right.
To be conducted कैसे कर सकते हैं?
To be conducted कैसे कर सकते हैं?
But is that in office?
That cannot.
That's otherwise
Auction conducted.
Or your lordships are just observed not to insist on payment. That's all. Then, my lords, if we probably that will the last sentence.
Right. Having regard to the fact that the issues in controversy in this batch of petitions is seized by the affect. Okay.
Right.
We'll simply say realist during the first.
Will depend upon the issues involved in the writ petition, in a bunch of these writ petitions and the writ appeal. Depends on the outcome of the special leave petition pending such and such. Give the detail of that SLP pending before the apex court. We deem it appropriate. We deem it appropriate to provide that till the disposal of the SLP pending before the apex court, or till any further order is passed by the apex court in that SLP, the respondent shall not insist for payment of tax, forest
development
tax /fee pursuant to the auctions held. Till the order granted today shall remain operative till next date of listing.
First week.
This is a combined order in all the petitions. So first write the detail of all the cases and then write it. Nobody is present.
Let him go back before the committee. He's not even appeared before the committee. So let him go back.
But this may not also survive, my lord, because what he's asking is with regard to an SOP that COVID-19 at the relevant point of time. Subsequently, revised circulars are issued with regard to SOP also. First prayer at page.
Party in person is absent. Full stop. The party in person also did not appear before the party in person committee also on 4/8/21. Accordingly, petition is dismissed for non-prosecution.
Prayer
in the petition, petitioner has sought for the following reliefs.
This public interest litigation.
I represent my lord, fifth respondent, my lord. My lord, before my learned friend could start, my lord, I will take, my lord, the impugned order, my lord. I'll just make one submission. Annexure A. Annexure A, my lord, 27. Lord, I am.
Yes, what do you want to point out?
Lord, kindly see, my lord, the impugned endorsement, which is Annexure A, second para. you were invited to the SCAC meeting held on 27/6/2019 and so on 31/7/2020 to provide required clarification and information. Since you remained continuously absent to the meetings, the committee apprised the project in your absence. As seen from the records, the proposed project location is very near to Kapatugudda Wildlife Sanctuary and no justification is forthcoming to take up this activity in this area. The committee hence recommended the proposal to SCAI for closure. My lord, they are absent, my lord, when we have called them. If they appear, my lord, we will reconsider their request for grant of environmental clearance in accordance with law.
He's conceding.
We will reconsider.
All right.
On 2 occasions, we have issued notice, they remained absent. They are not apprised. They are not.
I have already asserted in the petition, my lord. I myself and my consultant were present throughout.
Forget about anything. You go, he's saying, go and then consider.
In this petition, petitioner is sought for the following reliefs. Heard learned counsel for the petitioner and learned AGA for respondent 1 to 4 and learned counsel for respondent number 5. Full stop.
5 and 6.
5 and 6. 5 and 6. Full stop. 1 to 4 and 7. AGA for 1 to 4 and 7. Full stop. A perusal of the impugned order, impugned communication / order at Annexure A, dated 25/8/2020, will indicate that the said closure, the said order was passed by taking into account the continuous absence of the petitioner. Full stop. Petitioner / applicant. Full stop. It is submitted by on behalf of the petitioner that if one more opportunity is granted, not required.
Stated by him.
He says they didn't come, but we'll concession, sir. All right.
He's
Learned counsel for the respondents 5 and 6, on instruction submits that if the petitioner appears, once again, if the petitioner appears before the state level environment impact assessment authority, Karnataka, his application would be considered and appropriate orders would be passed in accordance with law. Full stop. The said submission of learned counsel on behalf of respondents 5 and 6 is placed on record. Full stop. Under these circumstances, we deem it distant.
Nothing remains to be adjudicated.
Under these circumstances, nothing remains to be adjudicated in the present petition. And the same is hereby disposed of by setting aside, by setting aside the impugned order / communication at Annexure A dated 25/8/2020 and directing.
Not setting aside. Shall remain in abeyance.
By directing the impugned order / communication to be kept in abeyance and by reserving liberty in favor of the petitioner to appear before the state level environmental impact assessment authority, Karnataka. It is respondent number 5 within a period of 1 month from today. Full stop.
And the expeditious order may kindly be passed.
They will pass the order.
I will be appearing, my lords, but they may take their specific date may be fixed.
Lord, 6 months, 6 weeks time may be granted, my lord, within thereafter. Once they appear, my lord, 6 weeks thereafter we will consider.
Expeditious.
Upon the petitioner appearing before the respondent number 5 authority, the respondent number 5 authority shall consider the application of the petitioner and pass appropriate orders as expeditiously as possible.
Please, no, please. Please, no.
Suppose after decide नहीं कर सकते.
Correct. This item, pray for 2 weeks time for filing
I filed application as per Annexure CH-1.
Amendment was allowed. Have you carried out?
I have carried out. Amendment carried out on 4/2/2020. Applications are pending from the 8/2019 for any one of my special license. Therefore, my only submission to the license is direct the respondent number 2 to consider and take appropriate decision on my application. Section G1.
Yes, what do you say?
I pray for some time not to file objections since there are criminal cases pending against the petition.
That sufficient criminal case was filed that has been closed. Thereafter, they have not taken any action.
All right, let them file the statement of objection. Learned AG appearing for respondent, press for is allowed 2 weeks time to file the statement of objection. Give it date.
Come for the petition. I pray for a week's time. I will rejoinder on the objections filed by the respondent in this case.
The counsel for petitioner press for is allowed a week's time to file rejoinder affidavit to the statement of objection filed by respondent 2, 3, and 4.
Started in respect of 2 and 3 months. Responded 2 and 3. Notice where it is a final disposal. Connected matter with file statement of objection. In this matter, they are seeking enforcement of the order passed by state level environment impact assessment authority.
Shall we direct Mr. Nagraj to?
Yes, Nagraj.
Shri Learned Counsel Shri D. Nagraj is directed to accept notice on behalf of respondents 2 and 3. Copies to be served. Learned AGA for respondents 1 and 4. Realist April. Statement of objections to be, if any, to be filed by respondents 2 and 3 by next date of hearing. Copies cut.
Appointee, my lord, is invested in shares. The respondent is a share broker, my lord. Share transactions to the extent of 33 lakhs rupees, my lord. I think 7 lakhs have been paid by the respondent. Balance 26 lakhs of is the issue. And the refer to the arbitrators, my lord, the GSE, my claim has been dismissed by both the arbitrators as well as by the court.
Matter is to be heard finally. We will fix a date. Give a date in June.
I appear for petitioner for respondent. Lord, I pray for adjournment. Kindly have it after vacation. I have certain documents from the DC office at Mangalore.
Adjourn on the request of counsel for the petitioner. This June.
Issued by the respondent, wherein Lord, he has asked me to stop querying activities, for which Lord there is no provision under the law. Lord, now kindly see the first petitioner, my Lord, has established a crushing unit in survey number 28/1, and the second petitioner is owning a query is Lord in some other survey number, that is in 42/1. Now the endorsement issued by the respondent is to stop querying activities for not having obtained a trade license.
We will hear it finally June.
Lord, I was asked to produce the additional documents, Lord, to establish the fact that the querying lease, period of querying lease is extended.
You file it?
Please, Lord.
You file it?
I already filed it.
All right, we'll hear it.
Please.
Plus.
हेडिंग के जो सिस्टम लगा दिए फिर इतने सारे सब फाइनल रेट तो लगी नहीं।
In this matter, municipality called for tenders to put up a commercial complex. And the existing vendors were evacuated, they were asked to vacate. With the condition that construction will be completed within a particular time, it will be given to them. Now, after the building was half completed, an objection was raised saying that it comes within 200 meters of the archaeological monument. Take permission. That stage, the court passed an interim order staying the construction. Now, what we have contended is the archaeology department can examine whether this construction will in any way affect the.
Who appear for archaeological department? Yes. We will direct you to do that. You have to solve the problem. You don't have to create the problem. If we will direct, then you will do it. We will direct to consider it.
Already rejected is. Already rejected is.
Already rejected.
That is rejected on the ground that this petition is pending. They are not willing to consider because of the pendency of the petition.
Have you challenged that rejection? Rejection is challenged.
That rejection is challenged in the writ petition.
Which one? 29 point.
29 points. What is that, my lord?
The first one is a PIL.
उसी की problem है ये.
शुरू हुआ. Unless they challenge the rejection.
हाँ तो दे किया होगा ना connected वाले में होगा.
नहीं वो दोनों PIL है.
You have challenged in which petition?
That is WP 51844 of 2019.
Whether it is here before the court. Huh? Then it has to come. But it has to be connected with this only, then it can.
They rejected only on the ground that they already commenced construction. They are not examined it on merit. And
So informed Mr. Senior Advocate.
Learned Senior Counsel appearing on behalf of respondent number 7 submits that during the pendency of this petition, the Archaeological Survey Department of India has rejected the application filed by respondent number 7, wide rejection order dated 16 September 2019, which has been assailed by the respondent number 7 in WP
51844 of 2019,
which is pending before the learned single judge. Registry is directed to put up the said petition along with these petitions and relist on.
There is a direction to go on with the construction.
That's what we'll get that. And if we set aside that, then this PIL will. Right.
The second matter, my lords. The challenge the allotment to the respondent.
We'll decide everything. June. But I think submission, Learned Senior Counsel said there is a permission to construct.
Here there is an order not to construct. There is an order to construct.
All that next week.
We'll see that.
Next week. Next week on date. Next week. Week after next. 31st March.
Next week. Senior counsel is not working. Kindly after Monday.
Time.
And for responding.
Time beacon.
He's seeking adjournment.
At request of learned counsel for respondent, release.
Monday, madam. So file will.
One second. 4th April. 4th April.
Monday.
Yeah, Monday.
Next month. My senior went to Telegram.
After taking the ex parte judgment.
Next week, any date.
Pendency of the suit, he himself executed the agreement of sale, I am not contested in the suit.
What is the shortest possible date? 4th April. Is it an admitted amount or a disputed amount?
It is a disputed amount. It is a disputed amount. It is only recommended by the district monetary
Committee.
And it's not an admitted amount. And one more ground is not in the recommendation itself.
Let us see the recommendation. Page. Annexure C, na? 43. Where is the quantification of that amount?
Page 44, column 12 minutes. CH-1. Compared to 43, proportion minimum to be written to the witness as per the remaining sign 20 rupees 20 per metric ton.
Deputy Director, Mahendra. This quantification is done by the Deputy Director.
That is extension of this 2011. There is no such extension at all in 2011.
This is the decision of the Ethic Monetary Committee. That
It is signed by the Deputy Director.
Deputy Director being one of the members, he conveys the order of the District Monetary Committee.
You have to comply with that. You have to comply with this, whatever you have said. Deputy Director has said on behalf of the committee and for himself that this is the amount payable to the petitioner.
That is contrary to the rules. That is what our contention is.
Then you will have to recall this. Having passed this order or issued this, how can you say that no, you will not comply with it?
Not because this order was passed in pursuance of the stand policy in
when is this order?
Year 2011.
Which order? What date is this order?
Not this order was passed.
2012, 10 years back.
2012.
Right. Once you have quantified it, you have to pay that amount. There is no disputed.
The dispute is this.
Sir,
for a period of
you
one.
yourself have quantified this.
Yes,
There is a question.
How you have done it in contrary to rules?
contrary to rules.
How you have done it?
That is wrong. That is wrong. That is one aspect
No,
of the
you
matter.
cannot take this stand.
Second aspect of the matter is, Lord, we have executed subsequent lease deed for the period 166 days. On the last occasion, your lordship was pleased to direct us to place it on record, the subsequent lease deed. Your lordship may kindly peruse the order dated 6/9/2021.
Sir, his grievance is the very same deputy director who quantifies the amount payable to him has rejected his claim for that amount.
Yes.
Where is the shows the rejection? Shows the rejection. Annexure?
That is impugned.
What is impugned? Annexure G. Page number?
Annexure G, page number.
Final hearing होनी है वैसे।
Final hearing.
कहाँ इस पर बैठे हो रहा है कहाँ से? Matter, you will have to hear it finally.
Annexure G is page number 16. And one more aspect of the matter is that deputy director apportions the quantified amount to be paid by Gram Panchayat half of the amount and the Department of Mines and Geology half of the amount.
Sir,
In
you
this
are
matter,
bound by your own order, sir. You are bound by your own order.
my submission.
Every order which you are bound and you have passed, if you are going to explain away and say that I did wrong, I did this, I did that, what is the point?
That is not permissible. Or you withdraw this.
My submission is.
Whatever you submit, the order binds your officer.
Yes, Lord.
What is the point? What is the point trying to submit?
I am trying to submit.
And do what? And say that that order is wrong. You want us to hold the 2012 order is wrong, is it?
No.
Then what do you want us to do?
Let me submit.
Then what do you want us to do? Let us accept that that order is wrong. Does it not bind
No,
you?
I am not submitting that. Even assuming that order is right. It is apportioned between two parties.
Where is the apportionment? Shows the apportionment. Shows the apportionment.
Subsequent is
The Gram Panchayat is not a party in this petition. That's what I am.
Sir, in that order, what is the amount payable?
Please.
And
Page number 76.
Payable by who?
Page number 76.
Payable by whom?
Page number 76.
Right.
According to the applicant CH-1, on the basis of remaining quantity of sand mining, the returnable quantity certified bid amount so and so comes to 9,22,200.
Right.
And out of this, from the Gram Panchayat, 4,61,100, and from the Mines and Geology Department, 4,61,100 is to be paid. My submission is that, Lord, in this petition, Gram Panchayat is not a party.
The amount collected, it has been paid by them. If it doesn't, they can collect in future. I have not paid directly. I have future contract between me and the company.
You are bound by your order. This is your reason to reject. Your reason to reject is that according to this order, impugned order, half is payable by Gram Panchayat, half is payable by you. Therefore, his claim for refund is rejected.
It is not rejected. It is not rejected.
Impugned order is what, sir?
Impugned order, not we have rejected in its entirety.
We can't understand, sir. You say not rejected. When we are showing it is rejected, you are saying not rejected but rejected.
That impugned order is rejection of the entire amount.
That's what, sir. That's what he has challenged.
Quantified by the.
All right. One date fix Marti. We'll fix a date.
It's
36.
Kindly pass out. Yes, senior.
Delay of 25 years.
The counsel for the case is urgent, give a date.
I require 2 weeks time to file my statement of objection to the IF filed by the
Pleading
Yes, I appear for the impleading applicant.
Sir, the petitioner wants time to file objections.
To my impleading application.
That's correct, sir. That's correct.
Very well, Lords. Lords, in fact, he should have implemented me as party because I'm going to be affected.
Time granted to petitioner counsel to file objection to the impleadment application IA 1/2022. List thereafter. Next.
I challenge because Karnataka Municipal Corporation Act as well as Municipalities Act.
What is IA early hearing?
Early,
Give a date.
consideration of interim prayer.
Third IA 2/22. List on it.
29 already fixed. 29.
Based on the date fix.
No, Your Lordship and
IA
Lords, sir.
disposed of.
My lords, appearing for petitioner, my lords.
Yes.
My lords, I am seeking for a early hearing in this matter, my lords. It's a revenue sharing agreement, my lords. The landowner is obstructing, my lords. There is urgency in the
Third
matter.
on IA 5/2022. List on 5th April disposed of.
Oblige, my lords.
Madhyana one day matter.
Article number 18. This honorable court gives permission to implead panchayat as respond number 34. It is not 34, it's 32.
ನಾನು ಅದೇ ಹೇಳಿದೆ ನೀವು.
Sorry.
ಆಯ್ತು.
34 I was waiting.
तो सही कर दो.
ಆಯ್ತು.
33.